Hi everyone, my name is Edna.
And I'm Mercy.
And this is The Real Conversation.
Your trusted guide to everything real estate here in Kenya. And today we are joined by a lovely, lovely lady here. She is Judy Kamoing, an advocate of the High Court. And we want to talk about succession, estate planning, and everything you need to know in terms legal before you buy that property or that piece of land. Right, Edna?
Yes, and securing your real estate. People who have houses or land, how are you going to make sure it goes to your kids safely without tussle? So we have Judith Kamoing to help us today. So Judy, hi.
Yeah.
Hi, thank you very much, guys.
Yeah, so tell us about you, who you are, what you do.
My name is Kamoing Judith. I'm an advocate of the High Courts, all the courts of Kenya. My specialization is in investment law, commercial, and brand protection. When I talk about investment, it is all encompassing, from real estate to structuring and financing of PPPs, to, individual conveyancing transactions. Yeah. Pretty much, and I protect your business and you 360 degrees, pretty much.
That's nice. I'm so happy we have a lady
in the
building, in power.
Yeah.
So I just want to talk about maybe how you started this journey. What did you study in school? Is this something you wanted to do from the get-go, or maybe halfway there you decided, I want to try this path?
I think in high school I was one of those people who were very passionate about, student rights. And I would often want to, push the students' agendas. And that's why I started it. I have a very good friend who's called Gladys Ochoko, and she said, Judy, you can really do well as a lawyer. And I started thinking in that line. But basically the interest grew from then, seeing, the society and the things that were happening in the society. I thought that people needed a voice. And pretty much. And I grew into it and I loved it. And I'm very, very passionate about law and individual rights and justice.
Okay.
Yeah.
That's really nice. Okay, so before we continue, we would like to get the weekly insight for this week. So Mercy will give us that, and then we'll have Judith.
Damn. So I'm going to talk about something I saw on the papers. Developers now have to get public participation before you change user or even develop residential or commercial building. I think the thing that started this interest is properties in Kilimani, Kilalashwa, Westlands, Lavington, Karen, where you've bought your unit. Everyone here knows the maximum number of floors is going to be 3. And then, someone has sold the plot of land next to you. The user has been changed, and all of a sudden you have 20-story building. Half of them are offices, half of them are residential. So I think it was people's outrage, and the environment court, land court, they decided to, before someone changes the user of their property, the land, you have to have public participation. You have to have approval by the residents who are going to be there. And I think that's really good. It's going to change the game in real estate, honestly. Yeah, so that's what I saw this week. That's what I saw this week. And I thought this is something that it can change how decisions are made. Yeah. And at least it will give the residents of that area or even investors, because now when you start buying property, at least you know the building that's going to come next to you, you're going to have a say in it. Yeah, so that's what I saw.
Yeah.
I don't know if it makes...
Yeah.
I don't know what you think about it, by the way.
I think it's important because we've seen people complain about high-rise buildings next to your window. You have your own house here, your standalone bungalow home, and you have a whole apartment in front of you. Now, I don't know how much the public participation will change.
Yeah.
But at least it's something.
It's starting.
It's a point of starting. So at least there's that. We don't know if it will cause any impact. If they say no, maybe they'll say no, and then the person can still build, but with warning. I don't know. But
implementation
with policies is usually what is the bigger issue. Yeah. But at least
it's starting.
Yeah.
I think that's quite insightful, because with public participation, then we also have accountability in terms of the people who are giving approvals. So I think that's a really good development.
Yeah.
You know, and that's quite something. For me, my insights for the week, or for the general public, I think couples and people in intimate relationships hoping to, invest together need to really rethink how they conduct their affairs. So many marriages in Kenya, whatever people term as marriages, are basically unregistered. And people cohabit in the hope that, they are married because, one party or the other party has expressed, or made roadside declarations of them being married, basically. So I think people really need to rethink that and how they structure their affairs, so that people need to think more about trusts. When you start investing, when you start making contributions to properties, to assets, you need to think about setting up trust, for the benefit of your children or other beneficiaries, or just structuring it that way so that you're protected.
And we'll talk about this more in the episode. But before we begin, a simpler question to start this conversation is, what is succession?
Yeah. So succession basically is how the transmission or the transfer of property from the dead person or the deceased person to the living people. So how that transfer is done, how do you succeed the property of a loved one who is deceased? So basically that is succession. How do you succeed?
Yeah. And then I think there are various types of succession. There's someone who, I'm saying top of my head, I know there's someone who has had a will before they died, and then there's someone they didn't have a will, but now they're battling this in court. And then I don't know if there's another. Are there what are the types of succession in Kenya? Testate. I know Testate. Now the lawyer will talk about Testate and something Testate. Yeah.
So we have two types, there is intestate succession, and basically when you talk about intestate succession, this is someone who has died without a will or without managing their affairs, so that they leave it to chance and fate. And I think many people are like that. You do not really want to think about a will or writing a will, because then you have to think about death. But then it's not necessarily about death, because there are also other legal instruments that can be used in wealth management, and also you have to cater for incapacitation. In case you get dementia and you're not able to, really manage your affairs, what happens, all right? In case you're incapacitated, you get into an accident, that hinder you from carrying on your kawaida duties. What do you really do? So apart from just having, succession, there are the wealth management strategies and legal tools that you can use, to be able to manage your affairs, your properties, and everything properly. So we have intestate succession, where someone dies without having a will. Then we have testate succession. All right. Testate succession is where someone has actually organized their affairs into a will, a written will, or a will generally, and they have designated who are the beneficiaries to my assets or my valuables, and what would really happen. In a will, you can basically state three things. What happens to you yourself? in terms of burial, your body. Do you want to be buried? Do you want to be cremated? Then secondly, what happens to your estate, your property? All right? How do you want it to devolve into the people that you care about? Then thirdly, you have what happens to, who are the beneficiaries of that asset. So basically that.
You've said something, and I think we forgot to put this because we're going to talk about will and no will and what you're going to do in marriage. Let's talk slightly a bit of what do you do, the instruments that you're saying when you're incapacitated. What are those instruments? Because I know there is a case where, I'll just give a story. There's someone who, I got married, I'll just say me. I got married, we got separated. And then now my husband, my ex, no, because now we are not separated through divorce, gets someone else. And then maybe my husband gets into an accident. And then now that he's not in a capacity to make decisions, so they look for someone to make his decisions. And now since I am his legal wife, not the one who he's with right now, so I have to make those decisions. But now my husband could have taken steps to enable him or someone, he would have said who he wants to give these instructions. So I'm wondering about those instruments that you've mentioned that are not particularly wills or what are those instruments?
So we have power of attorney. Power of attorney, basically what you're doing is that you're granting your rights and putting the person that you have appointed as your attorney to step into your shoes and do those things that you ideally would have done. All right? So we have general power of attorney where you just grant them all rights, including selling property, including collection of rents, and everything else that you would ordinarily, and running your bank accounts. Then you have limited power of attorneys where you indicate specifically what is the extent of this person that you have appointed, what's the extent. I mean, what exactly can they do? So you can limit it and say, just as regards to disposition of my property in Westlands, then that is exactly what they can do. They cannot go beyond that.
Can a power of attorney go beyond death?
No.
Yeah?
Yes.
So a will have to take...
Yes.
Okay.
Okay. So let's say in the case where people die without wills now, how is property shared?
Yeah. So when you die without a will, basically you have died intestate. All right? And every property that you own or assets that you have, the beneficiaries or the people, who would want to deal with the property would go to court and petition the court for letters of administration, so that you'll have legal representatives being chosen by the court. So the legal representatives or the administrators of the estate will petition for letters of administration. Then they will be given the rights to distribute the property amongst the beneficiaries. The administrators do not necessarily have to be the beneficiaries, but the beneficiaries also can petition to be the administrators. Okay. Yes.
Okay.
Yeah. So it is really up to the court to decide. The problem with dying intestate or dying without a will is that you leave your affairs open. All right? If you look at the definition of, dependent in the Law of Succession Act, it is so wide to even include a former spouse. Yeah. So I do not know whether it really reflects the dynamics of, the current relationships. Yeah. Considering that probably you've been with someone. You were with someone like 15 years ago, and you've really moved on and done everything else. They can come and claim, I was a dependent, so I need to be considered in this property.
And are they well in their rights to?
Yes, because it is provided by the law.
So, okay.
Yeah.
So, because this will affect so many Kenyans, I know, when the person
Many
who is
don't have wills.
People don't have wills. So, me who was living with this person, I have children with this person, I don't have like number one rights to this, or do they consider like your relationship? It's just everyone.
They consider your relationship, but I feel like it opens up your estate to so many other things and other claims, including children that you have educated before. You know, even if it's charity, then they're still dependents of your estate. You know, they need to be provided for. So I feel when you die intestate, you have not governed your affairs, and it leaves it open so that even the people that you really, really care about, say your immediate family, they might not get everything that was due to them. Because it will be challenged, then it goes and becomes very contentious. You know, everyone is filing an application and saying, no, but I need a piece of this pie, I need this and this and this.
How long does this process take in practice generally? How long?
Generally
for an intestate?
When it is contested, you know, contested basically means that there are other people who are coming up and saying that probably they are also children to your husband. You did not know he had 10 other children outside. So it becomes very contentious, and it takes a really, really long time in court. You know, because remember, the court does not only deal with this one person who has gone to court. By the time you're going to court, there are so many other matters. So you'll keep getting dates, and they're fast-paced, and it really takes time. We've had succession matters that have lasted 17 years, 21 years, and they're in courts. You know, they just have not agreed on how distribution of this estate should be done. They haven't agreed on who the dependents of this estate are, you know, and things just keep on coming up.
I have now two questions. One that ties to this. Let's say in that case, the succession has taken 20 years. What happens during those 20 years? Now, is rent collected? Where does the rent go? Do I still live in that house, me who was married there? Like, what governs the relationship with the people there who have now used the property? Because now people are fighting. I am the owner, I'm the owner. So does everyone like move out? Do we chase away the tenants? What do we do? What normally happens?
It really depends on the applications that have been presented before court. And sometimes you'll have court saying that every rent that is collected, you know, should be deposited in a certain account, you know, pending the hearing and determination of the succession proceedings, basically. Wow. But it really depends on what applications have been made. But when you think about that, it is really cumbersome. It is really unfair to your loved ones to just leave them like that, you know, because you need to structure your affairs in a way that it caters to the people, you know, that you love.
I can only imagine this rent was being used to pay for school fees for someone, and now they can't access school fees because mama someone from somewhere is contesting in court, or your wife from 20 years ago who you've not spoken to has come to claim that they need a piece of the land. So I see it's very cumbersome. People should have wills. And when now should I think of getting a will?
Think now.
Now would be the time to think of getting a will.
Even without, let's say, property.
You know, that question has been asked before, you know, and the way the question has been structured is that, do you necessarily need property for you to write a will?
Yes.
Yeah. And I was just looking at a decision the other day where a woman decided that they're going to will out their possessions, and, you know, not really possessions, their interests. They're very interested in collecting bottles, you know, shampoo bottles and this small bottles. And, you know, they had a whole collection of that, and they decided that is what they want to will out. All right. And the court actually allowed them. All right, because remember, apart from just willing out your property, there are other affairs that can be governed by the will. Yeah. For example, your children. Who do you want to appoint as guardian over your children? Yeah. Okay. In case they are still minors, then how do you want your body to be? Do you want to be cremated? Do you want to be buried? So I think. You can do it now. A will is a will. Although property lies at the center of it, but yes, you need to do your will.
I have so many questions. So let me ask, you've said in terms of how you want to, your final rites, either cremation or burial. And I think some communities frame against cremation. They say, Mungu akikuja atakupata wapi. So they want their loved one to be buried. So what if, I want just to give a scenario, I specifically said I want to be cremated, but my mother said hautanipeleka kwa shetani, lazima uzikwe. So what happens to now that scenario? Because me, I want to be cremated. People at home are fighting about me getting buried. So that's one question. Before we continue, another question. What if there are no children? What happens to the property? Yeah, so we start with the cremation bit.
Okay. If you desire to be cremated, remember, after you're no longer here, you do not have really much input apart from what you had written. Yeah. So most of the times, if you desire to be cremated, it's upon the executors of the will to step in and say, these were the desires of the deceased person that they desired to be cremated. But remember, any wishes that you state in a will should not be repugnant to justice and morality. You cannot say that, I want to be buried and I want to be buried in Wena's land. I mean, it really needs to make sense. Yeah. So it is upon the executors of the will to ensure that your wishes are actually fulfilled, because the executors step into the shoes of the deceased person.
Okay.
Yeah.
And now the scenario where, so let's say someone is a landlord in Ruiru and they've died. There's no children, no wife. Unapata people stopped paying rent. Like now the landlord hajakuja kunigongea mlango. There's people stopped paying rent. Now there's no one who's actually saying, this is my property. What happens to property now like that?
Property like that usually goes to Unclaimed Financial Assets Authority, UFA, and it eventually actually goes to the state. Yes.
Okay.
Yeah.
So how do they know? How do they...
especially for bank accounts. I don't know whether you've seen it. If you have a dormant bank account that has money, the bank will call you and tell you, are you activating this account so that you continue, or if you are not able to activate this account within a number of days, then whatever is there is going to go to unclaimed financial assets.
Damn.
So, yes.
Okay, I didn't know that.
I think that's fair.
Okay, that's fair.
But otherwise, it just disappears, because if you have tenants who have lived there for, say, 12 years, not paying rent, not being disturbed, then there's the principle of adverse possession. And after 12 years, they can go and petition and actually get the titles to that.
Oh, okay. So
get your will, guys. Get your will.
Yeah. Now let's go to the Testate pathway.
Yeah.
There is a will. So Edna has died. I know everyone doesn't like thinking about death, but let's say I have died. I left a will. How is it executed now from the day I passed on?
Yeah. We've covered testate, but I'm going to answer that. I do not know whether previously you're asking about intestate succession, where someone dies and they do not have a will, how their property is dealt with. and in case they're polygamous,
Yes.
how they're because we've already jumped to
yeah. Which part?
Intestate succession. So in case someone dies intestate without having a will, and probably they have several wives. Yeah. So the law of succession actually provides on how their property is supposed to be divided.
Okay.
Yeah. So the court would take the number of houses and the number of children. Yeah. So say you had 2 wives, and these 2 wives, wife A has 2 kids, wife B has 1 kid. All right. So they'll be considered as a unit. Wife A, 2 kids plus her, they are 3. So that's 3 over 5. You know, and wife B has 1 kid, so the child plus her, those are 2 over 5. Yeah, so that is how it is considered. So they divide that way. So the law of succession does not necessarily deal with equality in division of property. It deals with equity.
Yeah. Okay.
Yes.
Okay.
Yeah. So it's not like, oh, you had 2 wives, so it's going to be 50-50 distribution. So it really depends on the unit. So you have 3 units and you have 2 units here. The wives are included as a unit.
So if you guys are 17.
If
you guys are 17, it's 2 out of 17.
So if one person has 17 kids and the mother, those are 18. And this one has 1 kid and the mother, those are 2 units.
So it's 2 out of 20.
Yes. Wow. So that is how the distribution of that asset is gonna happen.
Interesting.
Yeah.
That's nice to know. I didn't know that. So when you go back now to when I have a will.
When you have a will, yes.
I have a will now. How is it executed from the day I pass on?
Yeah. So there are things that you need to first ensure when you write a will, that the will is actually valid. So that speaks to testamentary capacity. Okay. And capacity, when we talk about capacity, we are talking about your age. You know, are you a minor? Do you have the capacity to actually make this will? Okay. Yeah. Have you attained the age of majority to be able to make this will? Then capacity, we also talk of sound mind. Do you have the mental capacity, you know, to make this will? And mental capacity, I must note, does not refer to whether someone has a mental illness.
Okay.
All right? It doesn't refer to whether someone has a mental illness. But at that point that they are making the will, do they have an appreciation of what they are doing? Yeah? Yeah. Do they have an appreciation of how the assets will devolve? You know, who are the beneficiaries to these assets?
Is there a measurement metric of appreciation? Because now you say it's not necessarily mental illness, it's appreciation. What exactly does that mean? Because let's say
a person with dementia can make a will. You know, they forget. But probably at that point, they know that Austin is my child and Lydia is my child. And I need to provide for them. And I'm making this will and I have called in witnesses.
Okay.
You know?
Okay.
Because also sometimes mental illness does not cover everything. You know, it's not like someone is mentally ill and they're very incapacitated. They have lucid moments. They're called lucid moments. Yeah, where someone actually, you know, has the capacity, the mental capacity to make a will.
So one of these witnesses, it would be wise to call in a lawyer.
Yes, it would be wise to call in a lawyer to help you in preparation of your will. Yeah. So the law presumes that a person who has made a will is mentally okay, of sound mind, unless there is a rebuttal to that presumption. So it is upon someone who wants to state, oh, this guy did not have, you know, the capacity to make this will, to present evidence to show that, you know, they actually did not have capacity to make this will at that point.
Okay.
Yeah.
How do you get to choosing an executor? of your estate. Can I choose?
Just a minute. So we were talking about testamentary capacity.
Yeah.
So we said age. We talked about mental capacity. Yeah, and then a will is not invalidated just because an executor has not been chosen.
Okay.
But you get to choose whoever you want to choose as an executor to your will.
Okay.
All right.
Yeah.
A male person is called an executor. A female is called an executrix. Yes.
Executrix.
Yeah.
Okay.
Yeah.
Okay.
So an executor is a legal representative to your estate. Basically, they step into your shoes and ensure that everything that you wanted done is actually done. Yeah. So that if you had stated that a certain property is going to this person, they will ensure that all that happens. An executor holds, they maintain a fiduciary relationship, with the beneficiaries of the estate. An executor is not a beneficiary to the estate.
Okay. Because it brings conflict of
It
interest.
brings conflict. So they're placed in a position where they're supposed to carry out their duties and ensure accountability. Yeah. So executors are accountable to the beneficiaries of the estate of the deceased.
Okay. So legally, I know it's going to sound a bit, so legally I write my will, I have my witnesses. Do I have to do an application to the law to make it known that I have a will? What happens? Do I just store it with my lawyer?
Yeah. You can basically store it with your lawyer or deposit it in court.
Okay.
But your executor will definitely have a copy of your will. It is good to make like 3 wills.
Okay.
And have different people holding the will, including depositing it in court. There is the probate registry. And you can deposit your will there at very nominal costs.
Okay. Nominal costs.
How much?
How much are nominal
costs?
Flower.
Oh, okay. So that's easy.
There's that. So the person who stores it, they have the right to choose any means. So they can say, let me start. If Edna is my executor, can she use her lawyer to do this, to submit it to the probate registry, or it just has to be her? Like, can she share my affairs with someone else?
The executor can either act personally, to execute. To execute is to perform whatever the wishes of the deceased in the will, or the executor can use a legal representative. So you can have a lawyer for the executor to ensure that whatever the wishes of the deceased are executed.
Okay.
Yeah.
That's fair.
Yeah. So you will need to file probate.
Okay.
And it will need to go through the court process, and it's called propounding of the will, so that they are able to ensure or show that the will is valid. All right? And distribution takes place after that.
Haya, what if I told Edna and I wrote that you're going to have all my apartments, and then we are not friends, and then I want to change? What happens when I want to update something? I want to say Edna should not take this apartment when I die. What happens? Because now maybe I have what are the triggers? Like what processes should I follow when I want to update my will or revoke something in it?
When you're still living, you can update your will.
Okay.
All right. And you can also revoke whatever you had stated in the previous will. Only that in this updated will, you'll outrightly state that every previous will that I made before this is revoked.
Is now revoked.
Yeah.
Okay.
And this is the will that we're going to use.
So you have to say.
Yes.
You have to say that, or they will consider. Now, Edna, when I pass on, Edna will go to court and say, but
there's this will
that she said.
Yes.
Okay.
Yeah.
So
let's go now to the bigger chunk of this episode.
Marriage.
Property.
People have problems.
Kwanza, what? I know it may sound like a dumb question, but what is marriage?
Marriage. That's very, very interesting because I was listening to a conversation, and there was basically a webinar that was done by LSK Nairobi branch, and we had Justice David Riechi and Lady Justice Joaquin Dongo. And one of the sentiments that I found really interesting is when the judge was saying, sometimes when, people come to court and you ask the woman, when were you married? And this is someone who they've been cohabiting for long. Mm-hmm. They're not really able to point out that this is the day that we got married. Yeah. Because basically these people have been cohabiting. Can we stay? But when did you come to stay?
One rainy Friday in July.
But you know it was that Friday that you decided to stay.
Yeah.
Most people know when they decided to stay.
Yeah, so when did you get married? Then you say, we just... I came, I don't know. We had kids.
And then I couldn't leave, guys.
Yeah, absolutely. Mm-hmm. So marriage, according to the Marriage Act 2014, it's defined as the union between a man and a woman. Mm-hmm. All right. And it can either be monogamous or polygamous. Yeah. As long as it has been registered under the Act, in accordance to the Act.
Hold up. You've said polygamous.
Yes.
Yeah. Marriage can either be monogamous or polygamous.
Austin is laughing.
In the background.
I didn't know that it's allowed now to be polygamy. Like, wait.
Yeah. But polygamy has always been...
It's always been traditional.
Yes. But it's marriage, right?
It's marriage.
Is it not?
It is.
When did it change?
From what?
From monogamy?
No. Monogamy ni wewe ulijichagulia.
Ni mimi nilichagua monogamy?
Yes.
Oh, okay.
People choose polygamy.
So, okay, then why? Okay, guys, okay.
Stop.
I'm shocked. There's this process I know that when you're going to get married, you have to go and... so there's marriage in the church, 21 days, where they'll keep on announcing, Mercy is getting married to Byron. Is anyone against this? And they keep on announcing. And then there's something they also go and do in the courts and check if Byron is married. That doesn't happen. I made that step up in my head.
No, it's actually a step.
Yeah.
So there are different types of marriages. We have civil marriages. There are actually 5 types of marriages.
Okay.
So we have civil marriages. These are marriages that are done under the AG and all that. Then we have Christian marriages. Then we have Islamic marriages. We have Hindu marriages. And we have customary marriages.
Okay.
Yeah. Okay. So in that order, now take Christian, Hindu marriage, and civil marriage. Those are monogamous marriages.
Oh,
okay. All right. So in such marriages, you're not expected to be polygamous. It's monogamous. It's just husband and wife.
Yeah, Austin. Yeah.
Everyone else outside that circle, Then you have Islamic and customary. They are described to be polygamous marriages or potentially polygamous. So if you get married under Islamic or customary law, you cannot come and say after 2 years that, hey, this guy wants to be polygamous. It is potentially polygamous.
Okay.
Yeah.
Oh.
So many people here, I can see from their smiles, they want to convert to Islam so that they can not be at fault. I'm looking at them.
Well, they don't want to bring another wife.
They want to be, so when they're bringing another wife, they're like, but see, I told you.
Yeah.
So how do you know? Is there a way that the court shows, how do you prove customary marriages? Because I know with AG, it's signing, even Christian, you sign. Marriage. So how is customary, and how do we know that it's 10 of us here today.
Yeah. So when you do the customary rights according to your customs, and then right now it has to be registered. Customary marriages actually have to be registered.
Okay.
Yeah. You remember in that definition under Section 3, I said it's a union between a man and a woman, either monogamous or polygamous, registered in accordance to the Act. So the Marriage Act 2014 actually provides that all types of marriages should be registered.
Okay.
Yeah. So right now it's a requirement that you register your customary marriage. You went, did Rurasho, please.
So you can go to court and
come and register it.
Yeah.
Yes.
So Byron will go and say, I got married to Mercy. We had a Rora show and this was done. And then 5 months from now, Byron will go and say, I got married to Edna and it will be allowed. It will be okay.
Oh, yes.
That is
it's polygamous or potentially polygamous. So if you want it to be monogamous, just lock it in, man.
Yeah.
After Rurasho, register it, go to the AG and register it properly as a monogamous union.
Yes.
You know, so many people have this thing of relaxing after the dowry has been paid.
Yeah.
Yeah.
I didn't know. I didn't know.
Now we are married and there's nothing else you're doing.
Things are good at home.
Shaenda
home. Acha tutulie.
Now.
Yeah. So there's actually a requirement to register that.
Oh, and now, okay, after you said people in that discussion, people are asked, when did you get married?
Yes.
And you don't know. So so there's that thing for
Long-term
cohabitation.
Just say
after how long
can we stay?
does a come we stay situation become considered
a
a marriage? Does it ever?
You know, right now, the reason why we had the Marriage Act 2014 is so that it can make it easier, you know, to also recognize customary marriages. Because even in the presumption of marriage, you have someone saying, we've stayed together for 10 years. You know, we have invested together. We have done basically everything together. And there are children to show for it. But when they go to court, then that is challenged. Yeah. Because if it is probably a side chick and not the main wife, you know, who has been married probably under civil marriage or Christian, how do you really balance that? Yeah. So the Marriage Act came in to just state marriages should be registered.
Yeah. Cool.
Yeah. Marriages should be registered. We were relying heavily on presumption of marriages, and right now we are trying to make it a bit flexible for the court to approve it. Yeah, but you see, by the time you're getting to court and relying on presumption of marriage, it is because the marriage has broken down.
Yeah,
you know, you don't go to court when you're just married to tell the court, presume that we are married. And I wish that was the case, you know, before things go haywire. You can go and say, like, presume. And you see, something that I really find interesting in this discussion is that it is never the woman. The woman does not have the muscle to dictate how she's married and when she's married. Is that true?
Yeah, we spoke about that, and we thought, for sure, I can get on my knee and propose to the man. But will I tell him to marry me? Like, will I forcefully take him to our home?
Or will you take dowry to his home?
I can't take dowry to his home.
Sabairo amesema peleka ng'ombe juu unanitaka.
Peleka
ng'ombe nyumbani.
No, because I don't have the power to marry myself.
Yes.
He will have to marry me.
I love how you've said marry yourself.
Yeah.
Because why are you going down on one knee, Edna?
They said women empowerment.
Something was asked that I thought was so interesting and very thought-provoking. Someone asked, how is it that Kenyans do not have a problem, you know, registering a death? All right? They do not have a problem registering a birth. I mean, if you get a child, si atakuwa na birth certificate.
Atakuwa na jina ya father na mother.
You know, so you don't have a problem registering a death. You don't have a problem registering a birth. You do not even have a problem registering yourself for exams so that you get a certificate. What is this thing about a marriage certificate that people are very, you know, they are very reluctant to register?
Commitment issues.
Commitment issues, right? And there are so many other dynamics that come into play.
But now that you see how it brings a lot of conflict in the end, you may think it's ha. Yeah, she's moved in here, we have kids, yeah, we are married. But what if you now pass away?
Speaking of passing away, and we are sharing property. Yeah, let's talk property, and then we'll go talk about biashara, hizo vitu zingine. Wacha tuanze na nyumba. I've gone to court. This is the house I have given birth in. This is where we raise our kids. What claims do I have over this property that we own? And then there's this thing about matrimonial property. There's matrimonial, and then there's another type. So what's let's
dive
just
into
start,
it,
because today I've learned that polygamy is recognized by the law. Let me shield myself.
Yeah. So you know, the other discussion that we had was on cohabitation and presumption of marriage. You know, and at what point, you know, does the law presume you to be married? And then I say that we have the Marriage Act, you know, 2014, that basically provide that even the customary marriages should be registered. But customary marriages that you know, came into force way before 2014, they were given, I think, 3 months to have it registered. Okay. All right. But we've seen a lot of flexibility in court in terms of how courts, you know, basically give their decisions, you know. And there are courts that will say if you had a customary marriage and you did not register the same, then there is no point of us dissolving, because what do you dissolve? You basically dissolve a marriage, right? Yes, you basically dissolve a marriage. So if you want divorce, then you're divorcing on the basis that you were first married. All right. So we've had a lot of issues with that. Matrimonial Property Act kicks in, you know, to basically define what matrimonial property is. And matrimonial property is any property, you know, any matrimonial home, any property that has been acquired jointly by the parties during their marriage. Yeah.
Acquired jointly
by the parties.
Okay.
During the duration of their marriage.
Okay, so I have a question in regards to that. So say he acquires the property during our marriage. I understand the definition is clear.
She said jointly.
Yes, the definition is very clear. But does it mean any property that he acquired while we were in our marriage is not matrimonial property? It's his property.
No. The law makes two distinctions between matrimonial property and separate property.
Okay.
Yeah. Separate property is that property that has been acquired after marriage has been acquired not after marriage necessarily by either party to the marriage. All right. And it is separate and distinct. The law holds that if a party, now the presumption is that if a party acquires property during marriage, then they are holding the property in trust for either their husband or their wives.
Okay.
All right. But this presumption can be rebutted. Rebuttal basically means you can produce evidence to show that this is not it, but it is also subject to contribution. All right. So if you contributed to that property, then you can have a claim. But there are those properties that you acquire separately, you know, and it is your property.
Let's say because it happens in a lot of Kenyan homes, let's talk about it. The wife will go kando, buy a property, there's been a chama, she's been putting her money in, won't say anything to the husband, and we find out later in life, maybe when she's gone, she had a property, the husband is still here. That is not matrimonial property. That is separate, and has no say in that property. Okay.
But you've said the presumption. Can you... Yeah. That presumption bit, it makes it very open, isn't it?
Yeah, the presumption makes it very open, but also it kicks in to protect the parties to a marriage. Because sometimes, yes, it is separate property. You decided to buy a home, but me as your wife, I've come and I have done improvements on it. You know, I have painted the walls, I've put in the cabinets, I've made the kitchen. Yeah, so it will be regarded as if you're holding it in trust. For me. Yes.
Okay.
So you said contribution.
Yeah.
I can say, wait, I know it's his property, but I contributed to it. What counts as contribution?
Contribution is either financial or non-financial. Yeah. Financial contribution can be direct or indirect. All right. If I take in a loan and my husband has identified the property and I channel money to his account so that he pays, you know, that is contribution, financial contribution. But it's not that the money is coming directly from me to the property. All right. So you have direct and indirect contribution. Direct contribution is when you take out a mortgage or you outrightly buy and you can show that I actually paid for this property. And indirect is where indirect financial contribution is where you have also done something. You have also contributed financially to the acquisition of this property. Yes.
So in a case, let's say, there's a story I heard. This man and woman. So the man told the wife, "Why don't you do everything for the family, for the household, and then in the meantime, I do everything for us. I channel all the money towards this property. When I go to court, can I show that that's a contribution? I paid the fees.
Yes, absolutely. So we've talked about financial contribution being direct and indirect. And we also have non-financial or non-monetary contribution. So what would the court take into account when you claim non-financial contribution? Yeah, that you're the wife of this guy, you have offered companionship, or you're the husband to this woman and you have offered companionship that you have contributed into in terms of the management of the home care, child care, you know, even support, emotional support, and you can actually show that, you know. So you really need to be so detailed in terms of the contribution that you have put in. Yeah. So it doesn't really necessarily have to be financial, but the things that you have done to ensure that there is harmony in the home, there is growth, you know, you've taken care of the kids, man, you cook every morning, you know, those things. So they would actually count.
Do they want me to prove this?
Yes, yes.
So how do you prove it?
You actually state it. You need to state it. You do not let the court imagine. You know, there are things that you live, you know, it's like the court actually says, I can actually I can only imagine what you've been doing as a housewife. Yeah. So you need to detail them. What exactly have you been doing? Yeah. Companionship. What, you know, entail, how does it look like? You know, you've been taking care of the kids. State everything that you have been doing so that it contributes to you know, non-financial contribution or non-monetary contribution.
Yeah.
And now when we're in this conversation, it means the couple is in court, they're separating in this case, and now that's her property.
the division of matrimonial property kicks in.
Is coming in. So there is the matrimonial property. Now, Judith or Judith's husband had inherited property, right? Or was gifted property by the parents, and then you have the matrimonial property. Do I, the spouse, now Judith, have any rights to his inherited property or his gifted property as the spouse? We're not even on the side where we are assuming they were married. No, we were married. It's registered in court. It's as simple as Mr. X was given property by the parents. Do I, Judith, have a right to take a bit of
So where your husband has been given property, it's inherited, that would basically be deemed like a gift to him, right? So what would really count here is your contribution to this property, so that it would be classed as matrimonial if you can show that you have significantly contributed to the improvements to this property.
Question. Because I know this happens in a lot of Kenyan homes, especially where I'm from. The husband has property from his dad. The woman goes and toils or analima kwa shamba, right? Is that part of the contribution?
Yes. It is absolutely part of the contribution.
I know people ask that question a lot because now they might think they don't have any rights because it's their land, but umekuwa kilima, so
amekuwa kilima, amesha harvest.
But also remember the issue with non-monetary contribution or non-financial contribution is the issue of, are we able to quantify it? Yeah. So when it comes to division of matrimonial property, it is not outrightly 50-50. Yes.
What is it?
It is not outrightly. It can be depending on how you present your case in court.
Okay.
Yes.
Okay.
So there are instances, yes, it will be 50. There are courts who would give 40, 30, 10%.
Okay. So you've said, let's circle back to what you said. There is companionship.
Yes.
So what extent of companionship
allow
me to
let
guess?
us take all these factors into account. So you're looking at companionship, you're looking at the support that you have given, you're looking at childcare. It really depends from court to court. Some courts would award 50 depending on how you have presented your case. Yeah. Some courts would give 40%. So it really depends on how you have really presented your case.
So
not to say that all your efforts as a woman or as a housewife or a home manager comes to naught. It doesn't come to zero. Yeah, but it really depends on how you present your case in court.
Yeah, we are not saying that when people are in marriages to think that they will be divorced and now they start putting receipts down. But your advice would be ensure that you know exactly what you're contributing.
Yeah, ensure that you are aware, of the contributions that you're making.
Okay.
Yeah, in the home.
We more.
Yeah.
So a while back, we did something about now spouses holding property. There was something like joint tenancy and tenancy in common. So I just want us to do like a refresher. And now since you're talking succession, how does it play? So we can start by like defining joint tenancy and holding property. Now we are married. We have the certificates and everything. We want to buy property pamoja. So joint tenancy and tenancy in common.
All right. So there is a law of survivorship, which basically there is a principle of survivorship, which basically applies to joint tenancies. And joint tenancies is where you have property or assets being jointly registered. Okay. And the principle of survivorship basically states that where one person dies, then the surviving spouse will get the assets of the other party. Yeah. So that is basically joint joint tenancy. Yeah. So the living partner will take the estate of the deceased partner. The law views them as one unit. Yes, they are individuals having separate rights as regards that property. But then, from the outside view, the law views them as one unit. Yeah. So that when one party dies, the other one takes over. And you cannot have the estate or the portion. You know, there is no really division. Yeah, in joint tenancy. Yes. Okay. Then we have tenancy in common. Tenancy in common is where parties have registered their asset or their property as tenants in common. Basically, this means that when one person dies, and it needs to be indicated, when one party dies, then the share of the other party can devolve to their heirs or their beneficiaries.
But now in the joint tenancy,
it goes to the other guy.
It will go to the other person.
Yeah, so hakuna storia
will.
Yeah.
Okay.
Yeah.
So it would be wise as a couple to queer joint tenancy.
Yes. It's wise to be joint tenants. Let me go back to the issue of division of matrimonial property and what benefits, what protection people who, have matrimonial property would enjoy. So matrimonial property is protected in the sense that the other party cannot sell the property without spousal consent. This is where the issue of spousal consent kicks in. Yeah. So you cannot sell without spousal consent. You cannot charge without spousal consent. Then you cannot evict your spouse, from the jointly owned matrimonial property.
So even when you've said charged.
Without a court order.
When you've said charged, even when I'm going to get that mortgage from...
Oh, yes. You need spousal consent, yes.
Oh.
Because it has the potential of rendering the whole transaction void or, it will be nullified.
Wow.
So I can't sell the property we bought together, kisirisiri, or I can't sell the property you contributed to.
Yes. You contributed to.
Wow. Okay, so let's go to tools. So we have wills, we have trusts, I know people gift their children during their lifetime to make matters of succession easier. I don't know how true that is. You're going to get into that. And then we have nominations, or even a mix of all of this. So can you break down what all of these are, where they come in, and how I, as Edna, can decide what works best for me?
So everything that you have mentioned falls under estate planning. That is basically estate planning, where you actually plan your estate using these different tools, legal tools that are available. So you'll have wills where you have written a will and you have said that this assets will go to my heirs or my beneficiaries. Then you have trusts. All right. And trust, basically, there are 3 parties or 4 parties in the trust. There is the settlor. The settlor is the person who is creating the trust. All right. So Edna is a settlor. Edna incorporates a trust. Edna transfers all her assets into the trust. And Edna appoints a trustee who will manage the trust. All right. And the assets or whatever has been taken into the trust is for the benefit of the beneficiaries. So you're able to cater to your children. So we have the settlor, we have the trustee, and we have the beneficiaries. Yes. Then we can have an enforcer. An enforcer of a trust is the person who keeps the trustee accountable to the trust. So do we go deep into the trust, or I just touch on everything else that you have mentioned?
Yeah.
Just touch on it. Yeah.
So that
We can do
another
another session where we talk now
about even business succession.
Trusts and business,
Yeah. So we have the living trust and testamentary. You can actually incorporate a trust right now, and put your things into the trust and structure the trust however you'd want to. So and a trust can kick in after you have died.
Okay.
So there are two types of trust. I don't know what information to give you now that you have said I touched.
Okay, no, give us everything.
Okay,
please be free.
Yeah.
Let's do now, because we are talking marriage. Let's have a scenario so that we work with that scenario.
Yeah.
Yes.
So mother, father, child.
Yes.
Trust.
Good. So you have Angela and the husband Bernard. And Bernard and Angela intend to acquire property together.
Yeah.
All right. And they decide that the best way to do this would be to incorporate a trust. So they have the liberty to incorporate a trust rather than just leaving it, so that it will be determined according to the Matrimonial Property Act.
Yeah.
We have stated the challenges, that would bring, because we have to show contribution and all that. But just to cut off all that stress, let us buy this property, put it in the trust for the benefit of our children.
Yeah.
As simple as that. Yeah. So you have Angela and Bernard as the settlers of the trust, because they're the ones who have created the trust. And they can also be the trustees managing, or they can choose any other trustee to manage the trust. So when choosing a trustee, you need to ensure that the person that you appoint as a trustee is someone who is trustworthy, and someone who will conduct the affairs of the trust in good faith, and also they will need to account in terms of how they deal with the assets of the trust.
Yeah.
Then you have the beneficiaries, who are these two children. All right. And you can also appoint an enforcer of the trust, so that when you're not there, the enforcer can also be a lawyer or any other person who would actually see that the things that you wanted under this trust are actually being done by the trustee. Yeah.
Okay.
So
Yes.
for the married people, trusts are better, because now trying to account for contribution, as we have seen, even the non-monetary, it's very hard. How do I say what I contributed 10 years ago, unless I was
absolutely.
writing?
Okay, I have a question. Angela previously did the wise thing, started her own trust. Now she's married Bernard. It will be easy for her to appoint Bernard as the trustee. It won't be...
There is really no issue.
Yeah.
There is really no issue. And a trust is seen as a separate legal entity from the settlers of the trust, or the people who create the trust. So it's more of an asset protection. Mechanism.
Yeah.
So that the things that you put into the trust are not open to scrutiny, in terms of if you have creditors, they will not come for the assets that you have put in the trust.
That's true.
Yes. So it offers you that type of legal protection. Yeah. And also asset partitioning, in the sense that you have put your land into the trust. Then it is no longer yours, it belongs to the trust.
Yeah.
Simple question.
Judy.
Simple question that probably everyone is asking. Where do I go to create
this trust?
You just need a lawyer like me.
Yeah.
Cool.
Kesho. Because now imagine everything is protected.
Yeah. And I actually really encourage people, when we talk about prenuptial agreements, I'm sorry, I'm either going ahead of you.
Please go.
When we talk about prenuptial agreements, people have had prenuptial agreements, and mainly through TV.
movies,
and it has taken and movies actually, and it has taken a really negative connotation that you wouldn't even have the confidence to tell your man, can we sign a prenup? And basically what are prenups? These are agreements that are signed to basically state that whatever I acquired before marriage, it is my property, or to basically define even property rights within the marriage. Yeah. So you can easily set up a trust. Even when you're single, put in your things inside your trust. And manage them like that. When you get married, you guys can decide to either set up a trust or you move as you want to move, basically the way people are moving.
Yeah, because I'm thinking of a situation where I have my property and I would rather not have people coming to contest the property after I have left, or another woman coming in and say, oh, but when you were married, I was also there and I did this and this. I'd rather have it in my trust, and I know my child John is the beneficiary, and there's no one else, and there's no way anyone can come. Even my husband, okay, tumekosana, we are not friends anymore. Now you're coming to say that this you contributed, but I don't want you to have any part in that. So I'd rather my child John have my property under my trust.
I'm thinking if Kenyans or people are reluctant to write wills, please incorporate trust. It is for your own benefit. Just incorporate a trust. It helps you a lot in managing your own wealth and your assets and your properties. Just incorporate a trust.
There's someone whoever told me in passing in conversation, ati trust ni za watu wako na pesa. Because
is it not true? Really?
Because you see that thing you said about creditors. So waneka property zao watoto wao wapate, if in any case they're doing funny business or they have debt that they don't want their family to know about, or their debt is in business, their property isn't touched. So they put it in trust. But now that you're mentioning it, everyone actually does need a trust.
Can you speak about that myth? Is it true?
No, not necessarily true. I do not know where people get these notions, and I think it's from the movies.
From the movies.
Can we just filter?
From the movies.
It's actually from the movies and seeing these cartels and how they're running their affairs. Not really. It's not for people who want to hide their things per se, but it's just a wealth management tool. And an asset protection mechanism. But you have to be alive to the fact that there is asset partitioning. It is not your property. It is the trust. It is the trust's property, and you're able to cater to your beneficiaries, and also to the extent that you can be able to set conditions of this trust and say that, these are my rental units. All right, and they're earning this much, and I want 50,000 every month to be given to Joseph, my firstborn son, for this and this, or to be applied to his education or pocket money, and when he attains the age of 36, because I think he'll be very mature at that point, that he's going to own this property. Or even setting limits and saying that this property can never be sold to anyone else, can only be transferred to people within the bloodline. Wow. So you can really structure it in a way that you're setting the conditions that you want. It gives you that liberty so that when you're there, when you're not there, the things that you wanted would be done. And I've had so many people telling me, oh, Judith, I have 20 acres of land or 100 acres of land. I do not want it sold. I do not want it sold. What do I do? If you put that property in a will, it simply goes to your beneficiary. There is nothing you can do after that, because if anything, you're not here.
Yeah.
All right. But if you put it in a trust, you're able to set conditions and say, this property will always remain in the trust. It will not go here, but this person can construct, can do 1, 2, 3, can collect the rents. Yeah. For this duration of time. Yeah. I want to give my daughter this property, but this property cannot be transferred to the husband.
Okay.
All right. This property will remain with my daughter. If she wants, it will go to her children. Only blood relations will enjoy this property.
The work of my hands.
Yes, absolutely. So it gives you that latitude, to accurately plan your affairs.
Yeah.
Yeah.
You've actually answered. I wanted to ask you how succession now looks like in trusts.
Yeah.
But now it's easier. It's easier than...
Yeah, it is so easy.
It's
and
so
now,
much easier.
What did I want to say? Trusts do not go through probate. So at no point do you take a trust to court to be contested. No one contests a trust. You can provide for whoever you want in a trust, however you want in a trust. Only that you cannot provide for them from property that is encumbered or matrimonial property. I mean, you can't take your property and put it in your trust, matrimonial property and put it in a trust, and but you can be able to just arrange your affairs.
Okay.
Wow.
Yeah. Another thing that trust enjoys is tax incentives.
Okay.
Yeah. So that when you're buying property using a trust, you'll have stamp duty exemptions. And also the rental, Centum deals a lot with, rental income and all that, will not be subject to income tax as long as it's below 10 million.
Please repeat that for the people at the back. I don't think they've heard that they will not pay stamp duty.
Stamp duty is a lot.
So you will actually declare, but it is not compulsorily payable.
Okay.
Yeah, so there are tax exemptions, and you have to obviously apply depending on the tax regime that will be there at that point.
Time. Yeah.
Yes.
Anyway,
so that's trust.
So income below 10M, you might not pay. You'll get exemptions on education and medical and all that.
On education?
I'm saying you'll get exemptions, if you're getting income for education.
Yeah. I get now.
That's good. So we've spoken about wills, we've spoken about trust, we have gifts. How can I gift my child, John?
So it's actually really good that you've talked about gifts, because the law takes it that when you gift someone, you have gifted them absolutely, and you cannot take it back. So gifts are absolute in their nature, unless someone rebuts that by showing that, it was not actually a gift. The way people get married and you're given a car or a house, and then after a while, so gifts are deemed to be absolute in their nature unless there is a rebuttal to that.
So do I go to...
So there'll be a gift deed.
Okay.
Yes. You just prepare a gift deed and you gift.
They...
A living person has the latitude to dispose their property as they wish.
So I can just... My parent can...
But also having in mind the obvious limitations that would be there. Yeah. So it has to be theirs.
So gifting can go through probate.
Yes. Gifting is absolute, and you've done it when you're alive.
Yeah.
Yes.
Okay.
Hiya. As we come to
a close.
Yes.
But I think we'll have to come back and talk more about now. Now we've talked property.
Yeah, we've talked property.
We have more. We've not talked a lot. It's so wide.
Yeah, we've not talked about nomination, designated beneficiaries, chamas, circles, cooperatives. How does the law deal with that? I think we can store that and
we can do a part 2.
Part 2
for
we come back.
With even questions from the people. People who have actual real life experiences, something they're already going through, something they want to do with their property. They give us their experiences and what they would like us to talk about, because I would really like to know properties under Achama. My parents have shares. How do I deal with that? We know most parents, their properties in chamas. They have companies, they are directors, very different people in very different directors in the company. It doesn't have to be people in the family.
Yes.
How is that succeeded? Is that the right word?
Yes.
Yeah, how is that succeeded?
Which we'll plan for a part 2.
Because I don't want to rush through it.
Yeah.
It's very important. These are real life situations. But question. You've seen the tools that we have. I know you will say it depends from person to person, but what would you advise someone like
today?
Ingekuwa wewe.
Please just register trust, man. Make it a habit. Just make it a habit. Yeah, just register a trust. Yeah.
Takeaway. Takeaway of today.
Takeaway of today ni tengeneza trust.
Tengeneza trust. Even when you're in intimate relationships and you want to, or you're married, or however loosely you will define that marriage, and you have children, just register a trust. You see, most women are a bit shy when it comes to asserting their rights, as regards property. You're contributing umepeana 5M to buy a property, but you do not want to look like you're very materialistic. So you do not want to say, weka 1, 2, 3, which you should. I think it is something that we need to get rid of. But just register a trust. Whatever contribution that you're making, please make sure it's within a trust for the benefit of the children. No one would have a problem with that. Rather than just staying and hoping that everything would be fine. Yes, things can be fine, but always it is good to have a strategy, to know that you're protected, to be wise, to be prudent in how you manage your affairs.
I think.
And in commercial law, we talk a lot about exit clauses. I'm yet to know whether it applies to marriages, but yes.
It should. It should apply. Let's talk about the clause now. Now that we are signing this marriage certificate.
How about you talk about
why don't we put an exit and then you sign your name there? But anyway.
But loosely, what I just mean is that you need to think and embrace the good times.
And
you need to prepare for the future.
And
you prepare for the future wholesomely. So that you need to draw a worst case scenario. So what's the worst case scenario? Also best case scenario. And if this worst case scenario materializes, how am I protecting myself? How am I protecting my children? How am I protecting the contributions that I have made? What exactly are we doing? And I think Kenyans need to come to that point.
I feel like it's a good step with our generation and millennials and a few of the ones above that. We are trying to have hard conversations in terms of money, because people don't like talking about money. Hard conversations in terms of death. People are taking insurances just to ensure they don't
leave their family.
Bother is not the right word, but bother people who are left behind. We're now talking about trusts, because anyway, these are things that are happening in court and people keep it shush, like, wanapigania shamba, but tusingililie maneno yao, it could be you next. So we should have all the hard conversations, and it shouldn't even be a hard conversation, ni reality. We can't be la-di-da every day. Let's talk about in the scenario when we divorce, we might get divorced. What will happen? We may die, the both of us at the same time.
And also in the event that you're incapacitated.
It can happen. Hapo kwa stairs. You fall.
Thank you so much.
Thank you for coming.
Thank you so much.
Thank you guys for having me.
Thank you. So
I think I actually almost forgot that I was in a
studio. Next time it's going to be even longer and to the details.
Yes.
So that we help our parents who have those apartments in chamas and in circles,
they
don't say, and then now they've gone, and then now it's us who are left fighting for them.
Yeah.
So acha tukuje tuongelele those things.
So lastly, kabisa ya mwisho.
Kabisa
ya last.
Yeah.
What are like 3 things, or the number you would prefer, any property owner right now watching this should take to protect their estate and their family? What
actually
measures?
Know what comprises your estate. What assets do you have? Create an inventory of it. Yeah, designate and know that this property is matrimonial property. How are you guys gonna deal with it? This property is separate property. How do you intend to deal with it? How do you intend to protect it? So I think you need to constantly have an inventory. This is your life insurance. Who have you nominated as the beneficiary to that insurance? Have you updated in your circle? Have you updated the next of kin? You go everywhere and you write, next of kin. Have you updated? So have an inventory of your assets. Manage your things properly. Yeah, so that you have a view, and every time you acquire a new asset, put it in the inventory of assets and know and structure how you're going to deal with your assets. Yeah, what goes to your kids? How does it devolve to your kids? How does it devolve to your loved ones? So you really need to organize your affairs.
Basically organize your affairs, literally.
Yes.
An inventory is a literal list.
Yeah.
Organize your affairs.
And then you have someone
and get a lawyer. Kindly get a lawyer.
Get a Judith of your own.
Oh yeah.
Actually, Judith, we're finishing the session, and you should actually
plug yourself.
Yeah.
We're giving you 2-3 minutes. Plug yourself.
So I'm the managing partner of Kamoing and Company Advocates. I'm very passionate about investments. Investments are all encompassing. So you want to buy property, you want to sell property, you want me to come in, during matrimonial division of matrimonial property. I would be more than happy to plug in. We have our offices in 2 Rivers, 3rd floor, Kamoing and Company Advocates, and also in Nakuru. I also do commercial. So you have your business and you need someone to step in and ensure that everything concerning your business is legally sound. Starting from incorporation of the business, how you structure your shares within the business, whether you have investors coming into the business, how exactly do you structure those shares? I know so many people are used to incorporating businesses and doing the kawaida things. They do not really necessarily structure their shares and structure their companies properly. I do that for you, to the employees that you're onboarding. So everything that concerns your business, including expansion strategies, we are able to help you in that and ensure that your business is legally protected. And I also do brand protection. So brand protection is you as a brand, your company as a brand, your assets and everything else. Yeah, pretty much. So our numbers are 0733 281 337, Kamoing and Company Advocates. We are located at 2 Rivers, Southern Towers, offices on the 3rd floor.
We'll put it there in the description box.
We'll put it in the description box as well. Please, if you have any other questions, she'll be coming back this season.
Yes.
This same season for a part 2. Kindly ask the questions in the comment section. And as usual, Centum has made this happen. So, Centum is also in 2 Rivers, South Tower, 9th floor. We deal with properties in Nairobi,
properties in Vipingo,
properties in Entebbe,
land,
apartments, standalone homes, villas, everything you would need. Plots in the CBD. SEZ. We
Yeah.
have practically everything real estate. And as you have seen in the property of the week that has been before, we do a lot.
So yeah.
Call us at
0747-019-970 and we will help you. Also, if you need a virtual consultation and see which property suits you best, you can also call us or email us. We will put our links in the description box.
Yes, so that's 0747-019-977 or 970. Yes, so that's it from us. Oh, before we leave, there was that thing. Quote of the week.
Quote of the week?
Kulikuwa na quote of the week.
I did have a quote of the week, guys.
You have a quote of the week?
I
have
quote
one.
Of the week. I don't have. Give us one.
I have one. Give me a moment. Give me a moment.
Okay.
You can say where there's a will,
where there's a will, there's a way, guys.
Literally.
Quote of the week. Yeah.
From Eva.
Actually,
where there's a will.
There's a way. Come on.
And their trusts.
Yeah.
Please.
So yes.
Your quote yako ni gani, Edna?
Any your parents might not have made a trust, but Barack Obama said, we are the ones we've been waiting for. We are the change we seek. Tengeneza your trust.
One way. All right. Thank you so much.
Thank you so much, guys.
Bye.
Thank you, Judith. We should say bye together. Cindy.
Yeah.
So we'll look at this one and we say
This one?
Yeah.
All right.
So this has been The Real Conversation.
See you next week, same time,
Same place.
Bye.
Bye-bye.